So you can see all the presentation. Hi, my name is Matias Zubimendi. I'm the IP Business Advisor of the China IP SME Help Desk. Today with me, we are going to discuss and see what are the new challenges that pharmaceutical companies, EU pharmaceutical companies are facing when entering the Chinese market, or the ones that are already here. What are the new challenges caused by the latest amendment of the patent law? First, I will start with a brief presentation of who we are, what we do exactly. The China IP SME Help Desk, it's an EU-funded project, which main goal is to help all European and COSME region companies to protect their intellectual property rights in China. We do that with a set of services. Our main service is our helpline, in which companies can reach to us and ask any type of IP-related inquiry, from patents, trademark, trade secrets, copyright. All topic is good. Normally, we provide an answer within 3 working days. However, often we have been offering one-on-one online consultation sessions, so the companies can have a private session with us where we can discuss in confidentiality the case and start thinking a potential new intellectual property rights strategy. However, in the helpdesk, we also organize training, workshops, lately several webinars. In our website, you can find our blog. We have plenty of guides and fact sheets to consult, so companies can learn by themselves about the most important IP, intellectual property rights. And there are some industry-specific guides, so if you're interested in any specific industry, you will find all the intellectual property rights associated with the sector explained in detail. Here are some examples of our guides. This is me. Let's start. This is the content of my presentation today. I will start first explaining a little bit about the reform of the latest reform of the patent law. I will also make a review of the very basics of intellectual property rights to have a better understanding of what we are talking about. And then I will discuss 3 different challenges that companies normally face. Finally, some takeaway messages. When we talk about the latest reform of the pharmaceutical, of the patent law and the effect on the pharmaceutical sector, we have to think about 5 different aspects, 5 different topics that are the most relevant. The first one is the patent term extension. This is very specific for the pharmaceutical sector. We have the patent linkage system, a topic that I will not be explaining in my presentation because the following speaker will focus on this. We have an amendment also on design patents, a topic that I will not also cover, just to mention the life of design patent has been extended, and also now there's this possibility of using or for registering partial designs, which was not before, and it's considered in the world of patents a significant change. We have an increment of damages, and also we have the patent term adjustment for administrative delay. All these different topics, we will see them when checking what are the challenges and how these new amendments can become as an opportunity to overcome those challenges. But let's jump into the very basics of intellectual property rights that we need to know to understand how the IP works in China. The first aspect to cover is that for IP-related issues, China is divided into 4 different jurisdictions. We have mainland China, Hong Kong, Macau, and Taiwan. Each jurisdiction, we have to know, that works independently. So the registration we have in any of them will not grant us protection in any other. This aspect is sometimes forgotten by European companies, and this is a topic that we always try to remember, because a common scenario of a European company is that they start doing the registration in Europe because it's natural for them, they are from there, and then expand it to China using, in the case of patents, the PCT, which is the international agreement. I will go back to this topic later. The most important aspect here with the jurisdictions and the international agreements is that only mainland China is a jurisdiction that is member of those international agreements. So that protection that is coming from the international agreement will only grant protection in mainland China. And for some companies, other jurisdictions could be Hong Kong or Taiwan normally, are very important. And the companies believe that they are already protected in those territories when they are not. So this aspect is something that all EU companies should take into account. When I talk about PCT, I was talking about an international agreement. In the case of intellectual property rights, mainland China in particular is member of 3 big international agreements for expanding registrations. PCT, or the Patent Cooperation Treaty, the Madrid Protocol, which is for trademarks, and the Hague Agreement that China joined very recently, this 2022, for design patents. All these international agreements follow the same logic, let's say. A company that registers the intellectual property right in their own country, in their own language, with their own national office, they can simply expand it to third jurisdictions. They do so by applying for these international agreements, and the national office of their country will send it to the WIPO office, and then the WIPO office will send them to the national office of the respective countries that they chose. That is, in a nutshell, the logic. It provides many advantages because companies first can file it in their own country. They will be interacting with an officer from the national office, interacting in their own language, and also it's very efficient from the cost point of view because it's cheaper to go to pay just a fee, even though the fee will increase if you choose more countries. It's cheaper to pay that fee than going country by country hiring a different attorney. But again, we need to remember that in the case of China, only mainland China is a member of this jurisdiction. We have also the main principles of intellectual property rights we need to know, which are the registrations and the first to file. The registration principle is very straightforward. If you are not registered, you will have no protection. This principle is not so strict, let's say, in Europe. Some unregistered intellectual property rights are protected. However, this is not the case of China. And in the case of the pharmaceutical sector, in the case of pharmaceutical patents, it's not going to be the case neither. If you are not registered, you are not protected. So when we're talking about intellectual property rights that are, let's say, pending or they are not registered yet, we need to count them also as a trade secret, because companies should take all the protective measures that are possible in order to keep that secret as a secret, because patents, as we know, they have a legal requirement of novelty. And the second principle is the first to file, which means that the company that first files the application will have a priority over any other posterior attempt of registration. What is talking about registration? What is the challenge in the case of China? The challenge that companies face is that registration, generally speaking, is slow. It takes 3 up to 6 years. We have the promise that the CNIPA will try to reduce that time. We believe they will be capable of doing so. However, if we stay to what we have seen in the latest years, we still have to say that this is the expected time for a registration of the patent. But this registration time would not be so important, let's say, if it's not because of the fact that there's no enforceability during this period of time. Of course, companies can still send cease and desist letters, and they later, when the patent is granted, they will be able to get some damages from that period of time. However, it's a writing expectancy. We don't know if we're going to have the patent till it's actually granted. So for some companies, this provides a lot of uncertainty. In the case of pharmaceutical companies, we also have the extra layer of the market access requirement. Pharmaceutical companies cannot start selling immediately after getting the patent. They need to go all the process in order to get the market access, which reduces the actual commercial life of a patent. Even if you have the patent, if you cannot sell it, it's useless. You need to sell it. So you need it on the market for being available. What some companies, not pharmaceutical, but what some companies from the medical sector do, especially for those medical devices, to avoid this lack of enforceability, is using a parallel registration strategy, which means that they start doing the registration of the invention patent, but at the same time they start I don't know if you can see in the screen, there are some arrows. I don't know who is doing them. Anyway, what they do is doing a parallel registration of for medical devices. What they start doing to avoid the lack of enforceability is doing a parallel registration. They do that because they start the registration of invention patent plus utility models, and utility models are granted also in a very short period of time. Normally within a year, they're granted. So what they do is to use the fast enforceability of the utility model in order to overcome the lack of enforceability of the invention patent for the 3 up to 6 years. And then when they get the patent, they just discard the utility model. The new patent law brings some opportunities to modify or to overcome, this lack of the delay on the registration process. In the case of general invention patents, this applies for both pharmaceutical but non-pharmaceuticals as well. We have the patent term adjustment, which means that if there is an unreasonable delay on the administration for processing the patent, well, that delay can be recovered. The applicant can request the CNIPA to extend the life of a patent for the period of time that lasted the administration delay. There are 3 main requirements. The first one is that the patent has been filed more than 4 years ago. And also the second requirement is that 3 years must have passed from the request for examination. So if after filing the patent, 4 years pass, it passed 3 years from the moment in which we request examination and we still didn't have it processed, then we can assume that this delay is unreasonable and we can request our patent life to be extended. Also, a third requirement would be that this delay is not caused by the applicant. This is that if the CNIPA requests you to submit some sort of document or to provide some answer and you delay on doing that, well, that period of time that you delay, you cannot recover it back. In the case of pharmaceutical companies, we have a second option, which is the patent term extension. This applies for medical patents that were related by medicines that they need, of course, to go through this market access phase as explained before. They can recover or they can add to the life of the patent for that period of time that they are being processing the market access approval. It's only the requirements is that are only for innovative pharmaceuticals. The patent extension cannot be more than 5 years, and the total life of a patent cannot be longer than 14 years. Regarding enforcement that I was mentioning before, China is also a challenge for European companies. One challenge, or one of the reasons for the challenge, is the size of the market. For small and medium-sized companies, that is what we see normally at the help desk, sometimes the market is too big, in the sense of they cannot do surveillance, they cannot enforce in all the country, the costs are impossible to afford. So for those companies, they have to focus on one area, but for IP-related issues, you cannot simply ignore what's happening in the rest of the country. Someone is infringing in a province next to you. Even if you're focusing the market on one, you cannot just avoid it. A second challenge is that judicial cases are normally long. The processes normally take a significant amount of time. For SMEs, again, they simply cannot afford it. And finally, the third challenge is that for them it's very difficult to collect evidence. This is caused for many reasons. Lately, some COVID restrictions were also causing some difficulties to collecting evidence. But even before the pandemic, it was hard. EU companies sometimes they don't know exactly how to behave, how to prepare. Sometimes it's too late to get some evidence by the time that they reach a Chinese lawyer. So this is a real issue. As a tip, before going to the opportunities caused by the patent law, I would like to also highlight that in China we have IP specialized courts, which work very well, and for those companies that are involved in complex cases, which is normally the case of invention patents or pharmaceutical patents, going to these specialized courts are very recommended. This really was a game-changing decision from the judicial system, because it increased the level of professionalization of the courts, and before them it was really difficult to enforce a complex patent like a pharmaceutical patent can be, but now with experts it's much better. But from the opportunities brought by the amendment of the new patent law can be seen in two different aspects. First, from damages, and second, from evidence collection. In the case of damages, the patent law increased the statutory damages and included the punitive damages. So those companies that are behaving in bad faith, knowing that they're doing it, well, they will get an extra layer of damages, and even it's possible that they will be increased from 1 up to 5 times if they are causing a serious damage. Also, the normal damages, the statutory damage will increase up to 10 times. So this brought that it's not so easy for companies to simply infringe patents, because the compensation that at the end they will have to pay is just nothing in comparison with the profits they may get. It's not, now the question is not so easy. So that acts as a method to dissuade companies to infringe. But most importantly, the patent law brought reversing the burden of proving. Now the patent owner, if it is in a position that is very difficult for him or her to prove some damages, when the judge in court can request the infringer to provide that proof. This means that the infringer will have to show their books, their accounts, their movement of their commercial movement in order to prove the damages. If the infringer fails or doesn't want or provides fake evidence, they can be punished and they can be judged by the damages that predicted or estimated by the patent applicant, which this brings a more flexibility for patent prosecution, because the applicant can simply start estimating the damages and not worrying so much if they are capable of proving or not, as it was happening before. The third and last challenge that we will discuss today is the problem of licensing. The problem sometimes for European companies, especially for small and medium size, as we see at the helpless, because we realize that they have difficulties in negotiations. They could be caused because of language or cultural barriers that they don't know how to overcome. Lately, the pandemic brought travel restrictions, which made also difficult to interact, because all communication should be digital. For small and medium-sized companies, it's an extra layer of difficulty. But most importantly, licensing is a problem because sometimes the contracts are not enforceable. Contracts are not good. Normally see the scenario of a company that simply provides a license with a template of a contract that they downloaded from internet, which is far from ideal. We always encourage companies to have a tailor-made contract made by the Chinese expert, a Chinese law expert at least, and we always advise that this contract should be written in Chinese language with Chinese law applicable and China as the place of dispute resolution. If we are talking about the license for the Chinese market, it's going to be way easier to enforce it. And we normally see the case of a contract in English, and contracts in English are enforceable. And when you go to court, you will have to provide a translation. The other party will provide a different translation, or will provide their own translation, but it may differ in some clauses. And then who is right about the translation? And we enter into a new layer of discussion that we could avoid by simply having a contract written in Chinese language. And again, the latest amendment brought a new option for licensing that didn't exist before, and is capable of overcoming these difficulties that some companies have for licensing in China, which is the open license system. Now, companies can register with CNIPA that their patent is available for licensing. They simply set the rules. They said how much fees they want to be paid. They said any additional rule that they may want. The only limitation would be that they cannot choose to provide exclusivity for the patents, or the patents available to anyone. It's not only to the first person to come in exclusivity. And then any company that is willing to just get the license, they can start paying the fees, and the license will be provided. There's no need of even negotiation, because all the rules were preset by the patent owner. This brings some advantages. The first one is that it's going to be easier for the companies to negotiate, especially for small and medium size that they struggle with the communication. But also it has, if you submit your patent into this system, your annual fees will be reduced or even exempt. Finally, for those companies that may be worried about losing control over the patent when they include it in this method, you have to know that it's revocable. You can just take it out from the system at any time. The only limitation will be that the patents that you already granted, you cannot take them back. Finally, some takeaway messages as a closing of my presentation. According to what we have seen, remember that if you want to be protected, you have to register your IP in advance. If you're not registered, you are not protected. Pay attention to the jurisdictions in which you are registering. You have to register in those markets that are relevant for you. especially that are relevant now and maybe in the near future, especially in the case of trademarks. And if you're using international agreements, also pay attention, because remember that you only will be covered in mainland China. If you are entering into any set of contracts, have tailor-made contracts to be sure that they are enforceable. If you cannot enforce a contract, at the end of the day, you only have a simple piece of paper that worth nothing. The contract should be good. In the case of specifically for patents, extend the life or extend or adjust the life of your patents when it's possible. Choose correctly your jurisdiction. If you're going to litigate, remember that there are specialist courts that focus on intellectual property rights that are used to handle complex cases. You don't want to go with a pharmaceutical patent to a court in a small town where the officers are simply not used to dealing with this level of complexity. Before taking any legal action, remember always to collect evidence. Consult a lawyer before sending any notification to the other party, before disclosing that you're planning to take legal actions. Always talk with the lawyer first and try to collect and get as much evidence as possible. You will be compensated for damages as long as you can prove them, even though there is the burden of proof. Be careful of not diminishing your position by behaving in a way that you shouldn't. And finally, if you have any doubts, do not hesitate in contacting us. Here you can, in the screen, you can see our email address. We, as I explained before, we normally reply within 3 working days. And if you want to provide the feedback, you can scan our work.